I have with me on the podium this afternoon Mr. Justice Allan M. Linden. His Lordship was appointed to the Supreme Court of Ontario in 1978 after nearly 2 decades as a law professor at Osgoode Hall Law School. He is the author of a textbook on Canadian tort law, which is called Canadian Tort Law, and it's in the 3rd edition as far as I know. He is also the author of a case book out of which first-year law students study torts in most Canadian law schools. He earned his Master of Laws and Doctor of Science of Jurisprudence at the University of California in Berkeley, studying under Dean William Lloyd Prosser and Professor John G. Fleming. He has been visiting professor at the University of California at Berkeley and at the University of Melbourne, Australia, and Oxford University. And he has lectured at many conferences in Canada and abroad, published articles which, for the purposes of this introduction, are too numerous to mention. Mr. Justice Linden was a bencher of the Law Society of Upper Canada in 1975 until his appointment to the bench, and was executive director of the Canadian Institute for the Administration of Justice during that period of time. And it is with a great deal of pleasure that I now introduce to you Mr. Justice Allan M. Linden.
Thank you, Bruce, and thank you to you people who are interested in the law of torts, and allow me to stand up here and reminisce a little bit about this subject that I love so much, that I've studied for so long and talked about so long and written about so long. It was all I could do to twist the arm of Collins Williams to get him to organize this seminar so it would give me an opportunity to come back and talk about torts some more. Unfortunately, in my present job, I very rarely get torts cases. I'm not sure it's because the lawyers run away from me when they see me coming for fear that I'll make some terrible, wild decision that they'll have to go to the Court of Appeal to correct, or whether it's just the breaks of the game. But it just seems to me that I've got an awful lot of mortgage cases and mechanics lien cases, and I don't get enough chance to think about tort law anymore. So I'm grateful to you. And especially in this context, to be able to do a perspective, it's coming close to 30 years since I first studied torts, not in this room, but in another room with Sid Robbins, who was my teacher. And it's over 20 years since I started teaching the subject, so it gives me a chance to kind of gather together some thoughts about the subject that I'd like to share with you, and then following the talk, the other lecturers will be brought up here and we can have some discussion and some debate and some questions and hopefully end up the day on a good, friendly note. About 10 years ago, there were a lot of authors that were forecasting the demise of tort law. They said it was a dying institution, and those of us who are in the field ought to begin diversifying. I don't know how many people in the practice began switching fields, but I went and begged my dean to let me start teaching criminal law as well as torts, and he did. I was scared that this subject into which I had invested so much of my time wasn't going to be around very much longer. But that is no longer the case, as you'll see as I wander through a few of the pages that I've prepared for the book, that tort law today is no longer in danger of extinction. In fact, it's very much alive and well and growing and bursting with vigor and youth, and it's really quite exciting. There is a great deal that is going on in the field. The Supreme Court of Canada and other courts across this country have discovered the potential of tort remedies, and they've decided a great many cases that are very distinctive and many ways progressive and very humane. And it's a great joy to me to lift up a report of an English House of Lords decision in which they are quoting and citing and following and distinguishing Canadian cases rather than the other way around. And I've seen even in American decisions reference to Canadian cases. And that's because there is now a distinctive Canadian law of torts, and our judges and courts and the lawyers who are enabling the judges and courts to come to those decisions are really doing a job of investigation and thinking and putting the thing forward in a palatable way that can be adopted and disseminated. Until the midpoint of this century, however, there really was very little Canadian tort law to speak of, and I think that's understandable because you recall the Privy Council was really the last court for things Canadian, and really the law of Canadian torts was just the law of English torts. And so there wasn't much scope for development of a distinctive Canadian flavor. And of course, not so much as a result of that, but things were very difficult in the 50s. Ted Rachlin will remember when he and I worked in an office down on Adelaide Street trying to help some lawyers help some injured people recover a few dollars for their injuries. And I'll tell you, it was a very, very difficult time. There weren't too many easy wins in those days. There were so many difficult rules of law that had to overcome, difficult procedural things. There was really a lot of resistance to the problem of people who were injured. There wasn't insurance, there wasn't compulsory insurance, the limits were very low. There was a guest passenger section that forbade any guest passenger from recovering against his client. The old Valenti rules were very, very strict. And it was really easy to sympathize with those people who used to drag their battered bodies down to our office at the foot of Bay and Adelaide Street. We used to see them out there waiting in the waiting room with their crutches, with their casts, with their eye patches and their wheelchairs. And the hallmark that, of course, became so common, they're padding around their necks, remember, these awful braces that we made them wear that the doctors said would help them. And they used to wear them in public anyways, I guess. So it was difficult not to sympathize with those. But those were the days in the 50s when things really began to happen. The courts, whereas they had been looking at English cases, English text, almost exclusively, suddenly began to stir a bit. And I attribute some of it really to, well, a good deal of it perhaps, to the work of Dean Cecil Augustus Wright, who was in many ways, I think, the father of Canadian tort law. He did his doctorate in the field at Harvard under Francis Bolin, who was perhaps the most preeminent tort scholar of his time. And when Wright started to teach torts in 1937, he adopted a lot of the ideas of the American Restatement and some of the progressive work of people like Cardozo and Bolin and Prosser and people like that. And he developed this case book that he used through his classes at this law school until the break in the late 40s. And then in the 50s, when he went to the U of T, he put out his famous Cases on the Law of Torts. It had been a mimeographed case book before, but it finally got published, and it was really used in all of the Canadian law schools, and indeed throughout the Commonwealth in a great many law schools. And in it, he challenged the accepted principles of the law of torts. He, of course, included a lot of the English cases, but he had a lot of Canadian cases and American cases and articles and criticisms, and he was very much a pioneer in what was to become a Canadian tort law. And he wrote so many articles and case comments in the Bar Review, and his teaching, which John Bowlby yesterday described as electrifying, I think it really had a tremendous impact on those that sat in his classes. And the work and the ideas that he pounded into our heads, I think, helped us to better understand this subject and what it was meant to do. But he never wrote a treatise on tort law, and I never really quite figured out why he didn't. I think it may have been because he was so opposed to the idea of a textbook that would crystallize and rigidify the law that he didn't want to add to that problem, where the English textbooks used to state the principle and the courts would accept it and adopt it, and they wouldn't bend or vary or really look at the facts sufficiently and allow the thing to evolve. So I think it was more a philosophical thing. It certainly wasn't laziness, because he was a prolific worker. And I think it was a kind of a tragedy for Canadian tort law, and it would have been far worse had it not been for John Fleming, who came along with his book. And although it wasn't a Canadian tort law book, having been written in Australia, it looked at a lot of Caesar's work and the case book. I know Fleming used to teach out of Caesar's case book when he taught in Canberra in Australia. And it adopted a great many of Canadian ideas and Canadian cases, but primarily it was an effort to try and loosen things up and to open it up and to let the fresh air blow through the law of torts. And he was very, very successful in that. And it's strange that Fleming never really met Wright until the last year of his life, when I introduced the two of them in Caesar's office at the U of T in 1966. And Caesar died the year later, but it was as if they knew one another, because they wrote in the same journals, and they had very much similar ideas about what the law of torts was for and where it was going. I think these two books helped to foster much clearer thinking in this country about tort law and its purpose, and I think it formed a really strong basis for Canadian lawyers, and so many of them now have become judges and legislators, and the ideas generated there, I think, have begun to have a major impact in the shape and direction of our Canadian tort law, and I think in the years ahead it will have even a greater effect. So those were the 50s, and we were beginning to see our way to be free and independent, and we were beginning to get the tools with which we could do the job, and the stage was set for the 60s. And reform was in the air everywhere in the 60s, and in particular in the field of tort law, and especially in the area of automobile accident compensation, because that was where the problem was the worst, where tort law's inadequacies were so visible that there was a great debate about whether tort law ought to be abolished or what could be done. And there was all kinds of work, studies done in those days. We used to call the debate that over absolute liability, but it wasn't really that. And in '65, when Keaton and O'Connell published their book, we began to call it the no-fault debate, whether there was fault liability or no-fault liability. And I'm pleased to say that in the early 60s, there was a select committee of the Ontario legislature that was set up, and it adopted, or it recommended, the adoption of a scheme of no-fault insurance, which would be added to the existing tort system that would allow a certain amount of compensation to be paid to all injury victims who were hit by cars, and without denying them their right to sue in tort. It was a very controversial thing, and I can remember attending a great many meetings where people got up and they beat their breasts and they wept, and that same old principal of mine, who we loved so much, said, "What are you doing advocating this scheme? We'll be out selling pencils as a result of it." And of course, there was no way that anybody was going to be out selling pencils on the basis of this scheme, certainly, because it was a very, very clever compromise scheme that permitted a certain amount of compensation to everybody without destroying the right to sue. It was a scheme that I named later the peaceful coexistence scheme. I heard that word or that phrase used today. It was very popular in the 60s in the international plane, but it still expresses a very good idea where tort law could peacefully coexist with non-tort or no fault, and together they could achieve a certain basic form of compensation without removing the right to sue in tort. Now, during those days, it's funny, the argument went, should tort law be eradicated? Should there be this no-fault scheme, or what can be done to improve on things? And really the main thing, though, it seems to me, and most of us felt, was that we ought to get into place something that would at least put a floor on all of the victims of these car crash cases, and then we could discuss in the future about the role and the destiny of tort law. And that was done, as I indicated, through the 60s, right across the country. Much of that was picked up by the Americans. Their problems were far, far worse than ours, and they have a great variety of no-fault schemes that have been evolved in the United States, some of them far more radical than ours, but quite a number of them really just adopting the same ideas that we generated here in Ontario, which of course was based on the Saskatchewan scheme of 1946. But it didn't stop there, and in the 70s there was another wave of revolutionary ideas that were spread around this country and indeed the English-speaking world. The Ontario Law Reform Commission made a proposal that tort actions be eliminated in car crash cases. There was a plan developed by the IBC called the Very Plan, which would curtail drastically the role of tort law. And there was again a great debate going at all the bar associations and the Advocate Society and in the legislature. And in those days, though, it's strange that for me, coming through the 50s and the 60s, now it was in the 70s, I was among those who was attacking tort law in the 60s and saying that there ought to be something done for these injury victims, that we couldn't allow them to depend exclusively on tort law, at least the way it existed in those days. But in the 70s, I found myself defending tort law. I wasn't an attacker, but one who believed that tort law had some role to play and that we could resolve this automobile accident problem without diminishing the power and the importance of tort law. And a group of us in this little clan of hardy tort scholars, I was a professor, of course, then, and with other professors, some of them Canadian, American, Australians, we used to write articles and letters, and we'd meet at conventions and try to develop a theory for the retention of tort law, at least in some form. And most of us wrote different little articles about it. My little article said that we have to keep tort law because it can serve as an ombudsman, assisting ordinary people in their struggle for a more humane civilization by operating as an instrument of social pressure upon centers of governmental, financial, and intellectual power. This is what Tom Lambert would have called yesterday tort law playing professor, or tort law as teacher, or another version of tort law as deterrent. But it was a really different kind of tort law deterrent than what we had been used to before. It used to be that we considered tort law as a deterrent because of the financial awards that would be given against a person who departed from the standards of tort law, and they would be more careful in order to avoid paying. But then, of course, it was pointed out that in most cases there was insurance anyways, and that really there was no sting in tort law anymore. So we developed this notion that it wasn't so much the money that was being paid, but it was the publicity, the attention that was paid to the problem that could foster more care, more caution on the part of those who are engaging in dangerous activities. And these ideas, I think, were very much in keeping with the ideas that were floating around the West in the 60s, the movement for participatory democracy and issues like that. And it was felt by many of us that these tort suits could serve many of these goals of humanizing, sensitizing institutions in the society that perhaps were a little less interested in ordinary people and their problems than what we would have liked them to be. And so in these tort suits, the financial damage awards, although they weren't relevant, they weren't really the key to it all. It was rather the publicity generated by the tort actions, the educational power of being involved in those cases and of those who watched those cases, that was the important thing. And through tort actions, attention could be focused on social problems. And hopefully, as a result of that, whatever the decision, governments might react, institutions might react, the people might react, and hopefully the problem could be resolved in some way. And that's why we called it tort law as ombudsman. So, and many of us wrote articles, and I did too, showing how this tort law function percolated its way through many different areas. For example, the relationship between doctor and patient. The tort law has been involved for a long, long time in malpractice actions, and tomorrow morning you'll get a lecture about developments there. I think tort law has an important role to play there. helping doctors to understand the problems, helping the medical profession collectively to realize its problems. The recent case that you'll hear about, if you haven't already, I assume most of you have, Ribalhughes, that deals with the communication between doctor and patient, and just what has to be told to a patient when they enter the area of surgery or treatment, what kind of warnings have to be given. And there was a real intrusion there by the legal profession into the practice of medicine. And it's very controversial, of course. And the doctors are debating it all over the place and wondering what the lawyers know about what doctors ought to tell patients. But there's a problem, obviously. There are many people that feel that their doctors don't tell them enough. And when things go wrong, they come to court and they tell us, look, he didn't tell me about all of these dangers. Had he told me, I wouldn't have gone through with this operation. And every once in a while, one of those people is believed, and the court gives them an award. And it does shake up the medical profession greatly. Now, it's not going to do any major damage. The best bargain in this country today is still membership in the Canadian Medical Protective Association. I think it's $350. I think any lawyer would be delighted to have a $350 fee. Ours is what, double or triple that now, and most of us need, well, fortunately I don't need it in my new job, but because we're immune from suit. But we're not immune from appeals. But as I say, it still isn't a major problem. They're all dealt with in the same way. And I think what it is just an effort to try and get doctors to talk among themselves, to face this problem, and to come up with better methods of dealing with their patients. And the report of the Canadian Medical Protective Association, the year Ribalhughes came out, gave the medical profession the advice I think the Supreme Court would have wanted it to give. Treat the patient as though he were your best friend and you are telling him all about it. And I'm confident that if any doctor did treat his patient that way, there's no way the patient would sue. The patients sue the doctors that they feel don't care about them, don't talk to them, and the doctors they don't know. And I'm sure that all of us have seen that. You say to the patient, have you thought of suing your doctor? And they say, God, how could I sue the doctor? He used to come when the baby was sick, and they would never think of it if the doctor was really a friend and really cared about them and really looked after them. But when the doctor is somebody in a distant hospital that they never see, some big wizard who they just cart out to do this fabulous surgery, and of course he doesn't tell them anything, and something goes wrong, they do, of course, feel angry and hurt, and they possibly bring an action. So I think that's one example where tort law can help to teach, help to be an ombudsman, help to humanize human relations. And I could say the same sorts of things about lawyer and client. The same thing about police and citizen, and in the paper I've got some of that. There are problems in this society where people are unhappy with the way they're treated by the police, by their lawyers, by their doctors, by the press. There's been an incredible emergence of libel suits in recent years. I don't know if you've realized, if the newspapers carry a great many of them, but there's been a sudden resurgence of lawsuits, many of them by public people, political figures, and against public people. And the courts have become a forum for debate about the limits of free speech. Just how much can you say in a newspaper about somebody in public life? Just how hard can you hit? And as you all know, this notion of hard-hitting journalism is very, very popular now, and these newspapers are out there digging in the aftermath of Watergate, and they can be heroes and television stars and famous authors and run for politics and all of those kinds of things. And, you know, a really strong, tough, hard-hitting newspaper man can do a lot in his own career. It's okay. But sometimes they make mistakes, and sometimes they hit the wrong people, and sometimes they hit them with the wrong information. And you do get decisions like recently John Monroe's case against the Sun, where substantial damages can be awarded against newspapers in BC. The Deputy Minister of Justice out there sued the CBC and a newspaper man and received a $125,000 award, including punitive damages. And of course, the newspaper man ended up losing his job as a result of that. So to me, this is an important force, tort law, working out there, trying to teach journalists, whether they be journalists of print or the electronic media, that sure, they can hit hard, but they better be careful, and they better ensure that what they're writing and who they're writing about are deserving of the kind of criticism that they make. And if not, tort law is going to be there and award damages against them. There's a whole range of new activity in bringing actions against the government. And you heard something of that, I think, earlier today. You'll hear a lot more about it. More and more individuals wronged by governments are standing up and challenging them. And the courts are a little worried about getting into the supervision of governmental action, particularly through a tort suit where it's going to cost money. For a long time, we've reviewed governmental activity through the old prerogative writs and now through judicial review. But all that ends up doing is quashing the decision. It doesn't compensate anybody who suffered damages as a result. So there seems to be a gap there. And there have been a number of cases that have been brought against governmental officials for activities that they've performed that have caused loss, and a good number of them have been successful in the past. So here, too, tort law is an instrument of sensitizing government to the problems that they can cause if they botch up their work. You've heard just earlier the producer and consumer issue. And of course, tort law has, ever since Donohue and Stevenson, been available there. Now, so that was really the 70s, where, in my perspective, we were trying to defend the body of tort law from further erosion on the ground that we could improve the plight of the automobile accident victim without interfering with this other instrument that has come down to us for quite a while, until we were sure that it was no longer useful. And it's an odd thing that has happened. As we enter into the 80s, it strikes me that tort law isn't really being attacked anymore, that somehow most scholars and most authors seem to recognize that now that we've resolved this automobile accident compensation problem, at least to a large extent, now that we've got hospital insurance and Medicare and Canada Pension Plan and unemployment insurance that covers people when they're out of work as a result of injury to a certain extent, that tort law's role is not so much the compensation of injury victims, but it's more this educational deterrent function. And so not only is tort law having a little bit of a rest, but tort law is actually now going on the attack. Instead of being attacked, it's attacking other fields of the law that haven't moved along and haven't been updated as much as the principles of tort law, because in being attacked, it responded to try and adjust to those attacks, to try and justify its own existence. Other fields were let alone, and now tort law is moving into other fields. That great principle of Donohue and Stevenson unleashed 50 years ago. You know, we had a birthday party for the case of Donohue and Stevenson. You won't believe it, but last May the 26th, which was the 50th anniversary, a bunch of torts professors got together and we had a big cake and we sang, "Happy birthday to Donohue and Stevenson." We really did. It was a marvelous case. It's commandment to take reasonable care to avoid injuring your neighbor, which is a charming mutation of the Christian ethic of love thy neighbor, has infused the law of torts with a new vitality. And not only is tort law today sensible, secure, and stable, but it's energetically beginning to move into other areas of legal regulation which need renewal. And the more I think of tort law of tomorrow, I see its potential for modernizing and humanizing some of the more outmoded and rigid fields of law. I haven't had really the time in preparation for this talk to think these ideas through, but that's going to be my project by the time 1990 comes along. We have 10 more years of torts. I'll be ready to develop this idea, but let me just give you a few of the areas where I think tort law is moving in and helping the field to rethink itself, and hopefully for the benefit of us all. Take, for example, contract law. More and more we're seeing civil actions which were once based in contract now being brought in tort. Professional liability, which was once exclusively contract, you can see now being grounded in tort law, which means that not only are the contracting parties obligated to one another, but third persons can come in and take advantage of the relationship. In this way, short limitation periods can be overcome, procedural problems can be avoided, sometimes damages can be increased in the appropriate kind of case where contract law might not furnish damages sufficiently for that particular loss. We're seeing mental suffering being awarded as a result of breach of contract. And it's really quite ironic that tort law, in the simple tort case, it's sometimes impossible to get damages for mental suffering. And yet, if the action is brought in contract, the tort idea of mental suffering damages can be awarded. It's, for example, that Newell in the CP case where these people were going to Mexico on CP and they wanted to take their little doggies along and they wanted to take them in the passenger compartment with them, and CP said, no way, they're doggies, they go down in the hold, and oh no, not our doggies, we'll be glad to pay first class seats for them, no way, doggies go in the hold, don't worry, we'll look after them. Down in the hold they go, out they get in Mexico, and the little doggies are dead. They didn't take care of them as they contracted to do. And of course the people couldn't continue with their holiday, they came home and they sued CP. It wasn't a big case, but the decision said that they were entitled in contract to recover the damages for mental suffering, which CP should have known that it was foreseeable for CP that these elderly people who were so attached to these dogs, who were told not to worry about it, could recover. It's a strange paradox, but I see tort thinking coming into contract law and being even more influential in changing contract ideas than it is in the torts field, because if those dogs had been killed by being run over by a negligent driver, at the present state of tort damages for mental suffering, there wouldn't have been sufficient ground to compensate that. Of course, if it had been seen and there was nervous shock, that might be the case. But so to me, here's a tort idea infiltrating contract law and having an impact on enlarging it, shaking it up. Another innovation in contract law is the award for punitive damages. Now, I don't know if this is going to stick. I don't mean this, but there have been a couple of cases recently. Professor Friedman has mentioned them, I think impliedly, disparagingly, although he's always very respectful, at least in public. But there's a case of Justice Galligan, Nantel and Parisien. It was a breach of a contract of lease case, and these people had a lease to this building, and the landlords wanted that building down, and they just went in and smashed the building down. Just ignored these people who had their lease rights. And Justice Galligan found that they had exhibited the most arrogant behavior toward the plaintiff and her rights. They exhibited callousness toward her, and they were prepared to act as they did regardless of whether the plaintiff's rights would be violated by their conduct. They acted in a high-handed and shockingly contemptuous manner. They tried to steamroll her into acquiescence, and when that failed, they decided to push her aside like a pest. And Galligan awarded punitive damages as a result of that, on the ground that it was important in our society to try and deter people with power from abusing their power in an outrageous and shocking fashion. I picked that up and followed it in the case that's now before the Court of Appeal, Brown and Waterloo Regional Board of Police Commissioners. And although on the facts of that case I didn't feel it was appropriate for punitive damages, I said that this is a possibility in our law. And again, as I say, if it sticks, it will be another example of tort thinking infiltrating contract thinking, which historically never ever dreamt about punitive damages, but purely compensating for loss of expected profits and things like that. You were told a little bit today about torts in the pre-contractual setting, the way in which tort law, which has always been available if there was fraud, but now is also available if there's negligence, in circumventing provisions in the contract that say there's no warranties, no representations, and things like that. Our courts have said that where there's fraud or where there's negligence and where people rely upon that and enter into a contract, even if the contract says there was no such thing, if there was, they can either set the contract aside or award damages for that. And I think in the future we'll see more and more of that intrusion of tort law, which is with its very flexible principles, into the field of contract. And you heard a little bit about restitution and things like that. Restitution is doing much of the same that tort law is doing, and in appropriate cases I think it'll be available. In the area of criminal law, there's also been some intrusion of tort law, and of course all of these criminal assaults are also torts. All the rapes and the murders and the burglaries and the thefts, they're not only crimes, they're also torts. Unfortunately, tort law is unable to give compensation because usually the robbers, the rapists, the murderers, the burglars don't have the money or they're not found, and that's why we have Mr. Grossman and his board, which I view very much as a backstop to tort law, because if tort law were doing its job properly, and if all of these offenders could be caught and sued and they all had the money to pay, or if they were all insured, we could do without the board. But we don't have a world like that, and so we need the board. But in appropriate cases, where you have a defendant who's got money, or a defendant who's visible and who's suable, tort actions can be used either along with criminal actions or even instead of. And you're seeing more and more of these cases. Sometimes they don't really achieve very much, but there was recently an action, I don't know if you saw in the paper, I haven't got the report, but there was a young woman who sued her father for his persistent sexual abuse of her over many, many years, and she got a judgment of millions of dollars for that. Recently, Justice Keith here awarded damages of $25,000 to a wife because her husband kept beating her all of the time. Now, you're getting people bringing tort actions against others, and it's not always compensable, at least it's not always satisfiable, but still it gets things out, it allows people to say things. And I must tell you that there are times when tort law can be more effective than criminal law. If there's no evidence, for example, if the only evidence is what the defendant knows. In a criminal case, you can't compel him. If the Crown has no evidence, the defendant won't talk, there's no case. If he's sued, you can discover him. You make him talk, or else you hold him responsible for refusing to talk. And so you can get accused people or offenders possibly to answer in civil cases, where in criminal cases you couldn't. And it's even possible if a criminal action is brought against an offender and it's dismissed because of reasonable doubt, that the same action could be brought civilly, and because the standard is different, it might be successful in a civil context. Now again, this isn't generally utilizable, I recognize, but there are instances where it can be helpful. And I've noticed recently increase in the number of actions civilly for malicious prosecution, really both ways, between police and citizens and between citizens and police. But a lot of times citizens say the policeman beat them up, they're charged, they go to trial, they're acquitted, the policeman sues the citizen who lied, and they've been getting damages, just in the same way as it happens the other way. So we see these debates going on in the civil field that could easily be going on in the criminal field as well. And I see a similar intrusion of tort law into the administrative law field. As marvelous as that field is, and as much as we've reformed it and made it far more attuned to the problems of today, administrative law does not give compensation. And so you see tort actions being brought in an effort to achieve compensation, as well as the quashing of the decision. Just last month, tort law has re-entered a field from which it had been banished since 1914. See Mr. Riddle up here, the Workmen's Compensation Act. I don't know if you've had a chance to review that yet. Berger and the Willowdale AMC, the Ontario Court of Appeal, upheld a tort award to an employee who slipped and fell on the job when she sued the president of her employer, the company, personally, as a result of his own personal negligence. Now, she couldn't have sued the company because the Workmen's Compensation Act said she couldn't. She couldn't sue her fellow workers because the Workmen's Compensation Act says she couldn't. But these managerial people are excluded from that, and the Court of Appeal held that if she could get a personal action against them, she could conceivably circumvent the Workmen's Compensation Act. Now, there must be a reason for it. I suppose that with her injuries, she could have received more in damages than what she would have recovered under the scaled weekly or monthly sums that the Workmen's Compensation Act allowed. So we see tort law, with all its frailties, somehow being resurrected in a field like workmen's compensation, which was the indication how tort law had failed in that area and had to be taken over by a new scheme. So as I come to the end of my reminiscences and thoughts for you, I'd like to tell you that these are pretty good days for tort lawyers. I think it's not like the old days when people came into the office and you had to send them away saying there was nothing that could be done for them. Nowadays, it's becoming more and more possible for tort law to help victims of wrongdoing. And rather than an industry that's dying, as was forecast a decade ago, I think tort litigation is a burgeoning industry, one that young people could get into, and we're not going to be selling pencils at all. I don't think there's any more need to diversify, because tort law itself is diversifying. Now, it may be lagging a little bit behind that of the United States, because our courts, I think, are somewhat less adventurous than American courts. But that isn't all bad, you know. Canadians are a clever and a cautious people. We do not leap before we look. We don't embrace every new idea that comes along. We try to make sure that something will function properly before we choose to adopt it. Now, this style of life and lawmaking may be a little less exciting than some would prefer, but it's entirely consistent with the counsel of caution, which is the bedrock teaching of tort law itself. Canadians, it seems to me, in being careful about fashioning new tort principles, are acting in the best tradition of tort law. So as a result of all of this steady but unspectacular growth, I think tort law is a pretty decent body of law today, available to resolve problems of human interaction in a rational and responsible way. It's far from perfect, of course, but unlike many of the United States, we have not been cursed by inordinate delays. I think a good number of you may think 6 months or a year is a bit long, and it is a bit long, but it's not as bad as 4 or 5 years, as occurs in some of the major American cities. And we don't have these colossal damage awards that make insurance so expensive for ordinary people to afford, perhaps too expensive. They're getting up there in some cases, and the $1 million award is now no longer unheard of in this country. But we still haven't seen 10 and 20 and 30 and $50 million awards. Nor have legal fees been as exorbitant here as they have been in so many cases in the United States. And our courts, I think, have remained largely free of the kind of criticism leveled against some of the American courts for usurping the role of their legislative branch. In Canada, our courts haven't been quite as active, and they haven't had to be, because our legislatures, I think, have been much more responsive to the popular will, and there have been a number of areas that have been overhauled legislatively, like the Occupiers Liability Act, like may occur in the products liability field that occurs in the Family Law Reform Act, for example. We didn't need the activity of the courts to achieve those things because the legislatures resolved the problems themselves. And there are many more such studies going on. So all in all then, my Canadian perspective on this day of March 1983 is that tort law in the 80s fills me with some satisfaction about where we are, and it fills me with some pride about how far we've come, and also with some hope that we'll continue to keep Canadian tort law responsive and worthy of our respect. Thank you.